Warm up. For the record, Rule 12 will eliminate these delays in trial by providing that shortly before trial, the defendant will make known to the government his intention to rely on such a defense so that before the trial, the government can prepare to rebut the evidence of the defendant on this issue. The only point of controversy between the Senate and the House on this issue relates to subsection C, which provides that the court has the authority to order the defendant to submit to an examination by a psychiatrist designated for this purpose. The issue in controversy is the tension between the defendant's constitutional right against being forced to incriminate himself and the government's right to be permitted to respond to the defendant's evidence relating to his mental condition. We strongly and unanimously believe that the defendant's Fifth Amendment rights must be protected. We also agree that whatever statements the defendant might make in the course of the examination should never be admissible against the defendant on the issue of guilt. The statement of that second belief was contained in subsection C of the bill as it was introduced after consideration of this rule by the Subcommittee on Criminal Justice. However, the House passed a further refinement to the effect that such statements could not be used against the accused at all before the judge or the jury, which ultimately decides the guilt of the accused until that determination is made. The House rule would have the effect of requiring a separate trial in every instance in which a defense of insanity is raised. The Senate bill adopted the proposal of the Judicial Conference, which did not make any pronouncement of the admissibility of the statements of a defendant on a court-ordered examination. The conferees agreed to accept the provisions of the House bill as it was originally introduced in the House. The conferees believe that the courts will exercise their discretion as they have been exercising it for many years by either ordering a separate trial or making a limiting instruction to the jury in order to protect the defendant's rights. No defendant should be prejudiced on the issue of guilt by the receiving of evidence of statements admitted only for the purpose of determining the issue of insanity. We believe that experience in applying the rule will offer a firmer foundation in the future to determine whether or not further amendment is necessary in this regard to this rule. Rule 16 exempts the general rules of discovery, the work period of the attorney for the government and his agents, and the attorney for the defendant and his agents. The Judicial Conference did not propose to amend this exception. However, the House changed the language describing the substance of work product from reports or other governmental documents to the mental impressions, opinions, and legal theories. The change in this rule was to adopt the language describing work product as it was found in the Federal Rules of Civil Procedure. The Subcommittee on Criminal Justice adopted the amendment with the intent that the words in the civil rules better reflect the existing case law describing work product. However, since that time, much doubt has been raised as to whether, in fact, the words in the civil rules more narrowly define what is or what is not work product than the existing descriptions of work product as found in the criminal rules. For this reason, the Senate disagreed with the House amendment and agreed with the Judicial Council that the description of the work product should remain as it is today. The conference adopted the Senate provision. We agreed to this with the understanding that material or evidence otherwise discoverable under these rules cannot be protected from discovery by a label such as report or memoranda. It should be pointed out that the conference committee had no information that either the government or attorneys for the defendants were abusing the existing exemption. The subcommittee also received no information which would indicate that such an abuse exists. The Judicial Conference stated that nothing in the proposed rule decided the issue of what a statement consists of as it is used in Rule 16. The conference also notes that the American Bar Association has not attempted to define statements in this context because of a disagreement as to what that definition might be. There is no intention either in any action taken by the House nor in any action that we have taken to define the work statement as it is used in Rule 16. The final point of disagreement between the House and Senate in the bill relates to Rule 16. The House bill provides that the government does not have the right to discover certain materials. That was at 190. Okay. For the record, this is the case of Nile versus Holy Community Church. The facts are that Kathy Nile committed suicide. Kathy Nile had been a member of the Holy Community Church for over a year and a half. Kathy had consulted church counselors regarding severe depression and other psychological problems that had been plaguing her since her adolescence. Kathy's parents brought a wrongful death suit against the church and 3 other defendants, alleging that the defendants were aware that Kathy was suicidal and they failed to recommend that she seek professional counseling and psychological guidance. The plaintiffs also alleged that the defendants had an unwritten policy of counseling individuals that suicide in certain situations was an acceptable alternative to life. The plaintiffs allege causes of action for intentional infliction of emotional distress and hardship, and also an action for negligence for wrongful death. On a prior appeal, the State Court of Appeals reversed the summary judgment granted to the defendants. The court at that time did not address the negligence issue. The court held that the plaintiffs could state a cause of action for wrongful death based on infliction of emotional distress. This holding was based on a taped excerpt from a lecture given at the church, wherein the church regarded suicide as an acceptable alternative. Following a trial on remand, the court held that a duty to prevent suicide cannot be imposed on counselors who are not licensed as such in the state. The court held that because this was not a supervised medical relationship, that the defendants were not professionally negligent. The court also held that the fact that the defendants had knowledge that Nile may have been suicidal at various times in her life did not give rise to any specific duty for them to prevent harm. The court further found that public policy decision further upheld this opinion. The court concluded by saying that taped excerpts from the lecture were not probative. The statements on the tape were remarks made in a classroom to a group of students and would differ by their very nature from those statements that would take place during an individual counseling session. The court further stated that this opinion does not foreclose imposing liability in the future on counselors who act as professionals but are unlicensed. The position of counselor is a confidential one. The court must exercise discretion when imposing liability. That was at 200. Okay. Ready? For the record. Ladies and gentlemen of the jury, I'm going to refer to this exhibit very briefly during my argument. This exhibit shows aerial photographs of several diagrams. You will probably not be able to remember the marks that are made on here, what they are for and what they pertain to. For your benefit, the things I point out to you during my argument will later on be furnished to you in the jury room for you to look over and examine. As the court has indicated to you earlier, what I will be telling you now is not evidence in this case. Evidence comes from the witness stand. What I am telling you today is only what my impression of what the facts show. It is my impression of what the evidence discloses to you. Of course, some of you will sit back and probably wonder to yourself if it is evidence to consider and arrive at your decision. With the long process of the court trial, certain things that I have said, as well as certain things my opposing counsel said, may have been overlooked. What I present to you may jog your memory. What I present to you may point out to you a fact you forgot or overlooked. Maybe that is a fact that you would like to discuss in the jury room amongst yourselves. The reason we argue is with that particular motive in mind, to jog your memory regarding the facts in the case. Basically, I'm going to work from the transcripts prepared by our two reporters. I'm going to read portions of them to you to help you in your recall of certain facts brought out by the witnesses on the stand. There are several points that I would like to bring out for you and discuss with you. Now, there was defense put on for only one of the defendants, Mr. Brown. Mr. Brown took the stand and testified in his own behalf. Now, for you to consider the fact that one or two or none of the defendants took the stand should not be held against one of them or all of them. You may only consider the fact that a defense was put on. One thing that probably as jurors you should do is try to narrow the evidence down. Try to narrow the facts down to just exactly what the issues are in this case. I see two basic issues that have emerged in this trial. First, did Mr. Brown know that a crime was going to be committed? Secondly, did Mr. Shaw kill Thomas Cooper? As I see it, those are the two major issues that you're going to have to decide in this case. Now, if you look at the testimony from the stand, when I was examining several of the witnesses, they were very circuitous and evasive, if I may say that, in answering the questions. One witness in particular acted as though she did not understand the questions. I couldn't get a straight answer out of her. But remember, the testimony of one witness alone should not be considered sufficient to acquit or convict the defendants. If three of you see a certain sequence of events and later on you're individually questioned about that sequence of events, each of you will perceive that sequence of events in a different way. What struck an immediate impression on one person's mind may not even be remembered by another person. Now, all reasonable human beings differ a little bit. With that in mind, the basic story should be similar. But little things like who picked up the pot of coffee first, who opened the door first, who lit the cigarette first, those things may not have a permanent impression on your mind unless you're directly affected by the act. Then your memory becomes foggy. Ladies and gentlemen of the jury, I will begin my arguments with a close examination of Exhibits 15 and 17. If I may borrow the pointer from the clerk, please direct your attention to the front of the courtroom. Your Honor, directing your attention to each of the exhibits that are attached to the blackboard. Exhibits 15 and 17 have been received in evidence. May I mark those, Your Honor? 210. How are we doing as far as warming up? More? More. Okay, it's back to that Slater case, the legal argument. Okay, for the record. So that's the law of homicide. I ended with first-degree murder because when we get into how to prove first-degree murder, and also when we get into how to prove that the defendant is the one who killed Mary Slater, we talk about this concept called circumstantial evidence. And let's look at our elements that we have here for first-degree murder. Number one, a human being was killed. Number two, the killing was unlawful. Number three, the killing was done with premeditation and deliberation. Number four, Mr. Falcone was the one who did the killing. All right, now I'm just going to get rid of number two right now because I don't think there's any evidence in this case, and I don't think counsel is going to get up and argue that this was justifiable killing. There's just no evidence that Ms. Slater was attacking Mr. Falcone with a knife. There is no evidence that Ms. Slater was assaulting anyone at all. So we don't have the justifiable homicide that we are talking about. So I'm not even going to spend any time on number 2, but what's somewhat unique in this case is that a human being was killed, and the defense, according to Mr. Falcone's videotaped comments, is that Mary Slater is still alive. So we've relied on circumstantial evidence to show she is in fact dead, and that the corpse that you have up there near Mount St. Helens is in fact Mary Slater. What I'm going to get to is to show that in fact it is Mary Slater, and to show that it was done with premeditation and deliberation, and to show that it was Mr. Falcone who pumped those rounds of ammo into Ms. Slater in a deliberate and premeditated manner. In other words, he was the one who did it. We're going to rely on circumstantial evidence. We talked a little bit about circumstantial evidence during the voir dire process. I would like to keep this in mind. When we're talking about premeditation and deliberation, we're talking about what a person is thinking. It's impossible at the time of the killing to open that person's head up and look inside and see what the person is thinking. So therefore, we refer to actions. We refer to, or we rely on, what the person is doing. What is the person's conduct? In a homicide case, unlike a child molest case, a rape case, a robbery case, your main eyewitness cannot testify. Ms. Slater cannot come into court and tell you who it was that shot her. Very seldom do you have, witnesses to shootings. You have them sometimes. You don't have them in this case. What I'm getting at is that you rely on circumstantial evidence to prove not only what the defendant was thinking, but who done it, as well as in this case, who it is with respect to Ms. Slater. So we are talking about all of that. You heard the DNA experts testify. You must draw your own conclusions, and based on your own background, you have to draw conclusions from the evidence that has been presented in the courtroom. You have to make up your mind which way to go. What should I believe as far as the evidence is concerned is a question for each member of the jury to keep in mind when arriving at a verdict. Now, I am sure that Mr. Wiley is going to get up in his argument and say, well, if there is a reasonable interpretation, you've got to follow that reasonable interpretation, and he's going to be correct. That's going to be a correct statement of the law. But what you've got to do on circumstantial evidence, ladies and gentlemen of the jury, is consider all of the evidence. I'm going to try to use this as an example, and I'm going to try to show what reasonable explanations you can come up with concerning a fact. The defense is going to be arguing in that case that I guess Mr. Falcone, or I'm sorry, Ms. Slater, put the dress on the victim, and that's how you got the laundry tags that link up with the body. Well, there's no evidence of that. That's not a reasonable explanation. You've got to take all the evidence, the laundry tags, the height, the weight, everything else, and you put them all together. It's similar to drunk driving, where you have a person that's weaving on the highway and the officer pulls them over, and the officer gets out of the car and the officer smells this incredible odor of alcoholic beverage, and the officer has them do a field sobriety test, and the person is falling down and what have you. Then the defense says, well, gosh, maybe the front end of the car was out of alignment. That's a reasonable explanation. And maybe right before the officer pulled him over, the defendant took a big swig of mouthwash. That's why he has this odor of an alcoholic beverage. Well, you don't have any of this, of course. And then there's the reason he's walking very funny is because he had an old war injury. And the reason that, he hit his head when he came out of the car was because he has arthritis. Those are reasonable explanations for a specific fact. But what you have got to do in that case, in a drunk driving case, is put everything into a pot and draw your inferences, which is that the person was under the influence. How do you feel? Okay, more? All right. You're okay? All right.